Should police be able to seize a $42,000 car that they say was used to transport a few $100s worth of drugs? It's a case the nation's highest court will consider, and it started right here in Grant County. Now, in other states where the use of these metal detectors has been challenged before, police officers were the ones who were administering the searches. That's not going to be possible for all of these smaller Indiana school districts. If we take a look down here, there's been a trench dug so you can see these rhizomes, essentially roots, and they spread horizontally. They're really hoping the Trump effect, that double-digit win that Trump had here in Indiana in 2016, will translate to a win here for Braun as well. There's a provision in the state constitution that says any fines and forfeitures that are the result of someone breaking a state law should go to the common school fund. And these people say that's really not happening. A lot of police and prosecutors are simply keeping the money for themselves. The driveway where Tyson Timms lives sits empty.
It might sound silly, but it hurts my self-esteem. I'm a grown man that doesn't have his own vehicle.
Timms did have a vehicle 5 years ago. He used more than $42,000 in life insurance payments after his father died to buy a Land Rover. Police say he drove that car between Marion and Richmond several times in 2013 to buy or sell heroin. It was something Timms says he did out of necessity to fuel his own addiction.
I had ran out of my life insurance money, and I didn't want to be sick. You know, I had a little bit one day, and a guy called and said, hey, I have some people that, you know, want to buy some dope, and I took the chance.
But one of the buyers ended up being an undercover detective. Court documents say Timms sold heroin to police at least twice for a total of about $500. Police later arrested Timms and also took his Land Rover.
I was angry for a while. You know, to be honest, that probably got me through a long time, was anger and hatred. I hated the police for what they did to me, and I was going to show them, you know, I assumed that they probably expected me to fail.
While Timms pleaded guilty to 2 felony charges in his criminal case, he challenged the civil forfeiture. Timms doesn't think police should be able to take a car worth tens of thousands of dollars for a low-level drug offense. His attorney argues that violates the 8th Amendment's excessive fines clause. The trial court ruled in Timms's favor, saying the vehicle was worth more than 4 times the maximum penalty he could face in criminal court. And the Indiana Court of Appeals also sided with Timms, saying the seizure was disproportionate to the gravity of the crime. But the Indiana Supreme Court took a different position.
The Indiana Supreme Court took the state's appeal and decided, to everyone's surprise, that the excessive fines clause of the U.S. Constitution does not apply in this state, meaning that the state could take Tyson's vehicle, and meaning, in fact, that the state could take any user's property for even a minor crime.
That's something the U.S. Supreme Court will now have to decide after it hears the case later this year. But most civil forfeiture cases don't get nearly as far. It's hard to put an exact number on how many cases go undisputed because until this year, the state didn't require counties to report those activities. But experts say, more often than not, the seizures go unchallenged.
If you seize $1,000, but it costs you $3,000 to get it back, nobody in their right mind is going to fight. They're going to give up.
And that's not the only barrier for Hoosiers who want their property back. The seizures are handled separately from criminal proceedings in civil court. That means there's no right to an appointed attorney if a defendant can't afford one.
And that's a very troubling notion, that people are losing their property, not because they're guilty of some illegal activity, but because it's either too costly or too difficult, too complex, too time-consuming to fight back.
Hearing those kinds of stories is what motivates Timms to continue his fight.
It's not about getting my truck back, you know, for me. That hasn't been the case for me for a long time. For me, this is principle. You know, they shouldn't be able to do this to people.
In the years since police took his car, Timms says he's made a lot of changes. He's now clean and even speaks to local and state task forces about his battle with addiction and the criminal justice system. and he has a job. But he has to borrow his Aunt Wendy's car to get there while she takes the bus to dialysis.
We don't all have an Aunt Wendy, so there's a lot of people like me that they're stuck.
It's those people Tim says he'll be thinking of as the Supreme Court hears his case.
I'm here to help if you guys need help, most definitely.
Joel Wenicky is standing in front of a classroom at Logansport Juvenile Correctional Facility. He's talking to a group of boys who arrived here within the past week. They range in age from 12 to 17 and sport the same shaved heads and gray sweatsuits.
So right now is what we're going to do is we're going to talk as a group, but you guys got to raise your hand if you want to talk to me, okay? And we're going to try to figure out what you guys know about the system it is that you just went through, how it is that you came to be here at the DOC.
Wenicky isn't a teacher, but an attorney with the Indiana Public Defender Council's Juvenile Defense Project. The group developed a memorandum of understanding with the Department of Correction to let attorneys visit 2 juvenile facilities in the state every other week. Wenicky drives more than 4 hours round trip to make sure the kids who are serving time in the DOC had proper legal representation.
It sounds like everybody in the room had an attorney, right? Because that's one of the things that I want to find out and make sure that you guys know and understand that you had an attorney. I've met with 7 kids so far since last April who made it all the way here and didn't have an attorney, at least at some point in their case, when they probably should have.
It's hard to gauge how often that's happening in Indiana because there's little statewide data available on juvenile defense. The state itself collects little information on kids who go through court or end up in the DOC. What we do know from judicial service reports is that about a quarter of juveniles waived their right to counsel in 2015. The National Juvenile Defender Center worked with state task forces to complete an assessment of Indiana's system, but that happened more than a decade ago. The analysis took information from 11 of Indiana's 92 counties and points to issues with how and when attorneys are appointed to juvenile cases, and the high number of kids waiving their right to an attorney. What Wenicky knows from his visits to Logansport is that some of those problems still persist.
They show up at the Department of Correction oftentimes not knowing and understanding things that they should understand having gone through that process.
Wenicky has no shortage of stories about kids who ended up in the DOC when they probably shouldn't have. He estimates about 45% of the boys who sit through the group orientation request to meet with him one-on-one because they have questions about their situations. Wenicky skims their case files quickly before they have a private meeting.
I talked to a young man not too long ago who, after sitting through orientation, he wanted to meet with me one-on-one, and he came in and he said, I don't think I had an attorney. And so we had to talk through who were the people in the courtroom, and the only thing he could say was the person in a suit with all the paperwork was sitting at another table.
There's a long list of similar stories, like the girl who lied to a police officer about her name, which would carry a maximum penalty of about 180 days for an adult.
She's been under court supervision for that offense for 3 years, had multiple probation violations for things such as skipping school, but that it's kind of hard to see that that should be the hook, a B misdemeanor, to keep court supervision over her for 3 full years.
Based on conversations like that, Wenicky connects some kids with an appellate attorney or the state public defender's office. His colleague goes through a similar process at another juvenile facility.
So we've had about over 400 kids go through the orientation. About 40% sign up to talk to us, and then out of that, about 10% we've referred on for appeals.
The facility visits are just a portion of Indiana's plan for improving juvenile defense. Attorneys are also going to counties to help them reform the way they deliver juvenile justice. And there's an effort to give attorneys more juvenile-specific training.
By the time the grant's over, we hope to have at least done training for attorneys in every single county.
But access to quality counsel isn't a problem unique to Indiana. It's happening across the country. The National Juvenile Defender Center says the practice of automatically appointing young people an attorney hasn't caught on everywhere.
67% of the states that we've been in, young people were not always waiving their right to counsel, but at least in some places were appearing at proceedings where their liberty interests were clearly at stake. Detention hearings, adjudication hearings, disposition hearings, without attorneys at their side.
Scally says the problem is systematic, and the lack of funding and consistency in Indiana only compounds it.
You look at the fact that there's no state-level entity that provides leadership, oversight, monitoring. There's no mandatory standards for counties to comply with that demand that young people get quality juvenile defense.
That's in the back of Wenike's mind as he talks to these kids. Federal grant money supporting this program runs out next year, so he'll have to make his case to state legislators to support the program. He says there's evidence to show their efforts are working. The DOC released a couple of kids early after he discovered they shouldn't be there. But they're only dealing with a small number of the thousands of juvenile cases in Indiana.
We're trying to reach out to residential placements and secure detention facilities, which is a step down from the Department of Correction, to encourage them to get kids in touch with us who may have an issue, but we just can't, travel around and do this same orientation interview process at those facilities. It would take too much time.